All right, it's 11:01, so good morning, everyone. My name is Alexis Susi, and I'm the Director of Media and Stakeholder Relations for the Office of Cannabis Policy. On behalf of the entire office, we thank you for joining us here today for our 2024 Enacted Cannabis-related legislation webinar. Before we jump into today's presentation, I have a couple of quick housekeeping reminders. First, today's webinar is being recorded and will be made available on OCP's YouTube channel. Second, we ask that you please use the Q&A feature at the bottom of your screen to ask questions throughout the event, and we'll have time to answer those questions in more detail at the end of the presentation. OCP Policy Director Gabby Pierce will be joining me today to discuss updates on legislation and rulemaking. We'll start with implementation timelines, then we'll go into legislation affecting both cannabis programs, the medical use of cannabis program legislation, the adult use cannabis program legislation, as well as the adult use cannabis program rulemaking. OCP Director John Hudak will then join us to discuss federal rulemaking for the rescheduling of cannabis. And we have a lot to get through today, so with that, I will turn it over to Gabby.
Good morning, everybody. Thank you for joining us. I am going to start off by talking a little bit about implementation because we have already gotten a bunch of calls and questions about it, so I want to make sure everybody is on the same page with respect to the timelines related to implementation of new legislation. Specifically, I want to remind everybody that emergency legislation goes into effect as soon as that legislation is signed by the governor or 10 days after it is enacted by the legislature, so long as the governor doesn't veto it. If it can go into effect without her signature. We have one bill this year that was a piece of emergency legislation. It was the bill related to the use of the universal symbol, embossing or marking the universal symbol on edible cannabis products. We'll get into that a little bit later, but that was the only emergency legislation that went into effect this year. For all non-emergency legislation, which is the bulk of what we'll be talking about today, that goes into effect 90 days after the legislature adjourns, sign and die. And so the effective date for all non-emergency legislation passed during the second regular session of the 131st legislature is August 9th, 2024. So certainly keep an eye out for additional guidance as we approach that date. And I am going to do my best to highlight as we go along those things that have already gone into effect, those things that we as an office are able to implement before that August 9th deadline, and those things that will require additional rulemaking or updates to your plans of record and approval by the department before you can implement those. So without further ado, we'll continue right along. I've mentioned already some of the changes enacted by the legislature, and some of the this session, this spring, as well as last year, require major substantive rulemaking in order for our office to implement those. We've been talking about chapters 10, 20, and 30 now for about a year. I think we touched upon this last year as well, but the legislature did authorize us to finally adopt the adult use cannabis rules that were promulgated last year. And so the adult use cannabis program rules, chapters 10, 20, and 30 were all major substantive. Major substantive rules must be finally adopted within 60 days of the effective date of legislation authorizing their adoption. So again, that's that August 9th date. And those rules go into effect 30 days after they're finally adopted. So it's our expectation right now we're going to be able to get those rules finally adopted in September of this year. So those are going to effect 30 days after that. So we're looking at around October for implementation of everything, even that stuff that requires rulemaking. We should be done with all of our implementation by October, with one key exception, which we'll get to in a minute. Thank you. So I'm going to start off today talking about legislation affecting both cannabis programs, and then we'll get into each of the individual programs individually. So the first is an act to establish the social equity program. This bill, LD 1517, Public Law, Chapter 683, establishes a social equity program within the Department of Economic and Community Development and an apprenticeship program over at the Department of Labor to support members of impacted communities, and there's a definition right in the in that law if you're interested in getting more information. It's also covered in more detail in our written legislative roundup, so feel free to take a look at that as well. It also establishes a cannabis business advocate position within the Department of Administrative and Financial Services to assist current and prospective program participants in navigating the regulatory system associated with cannabis businesses. And again, that law doesn't go into effect until August 9th, so I would keep an eye out for that position popping up sometime later this year. Next. The next is LD40. I'll read the title once, and then I just want to, it's a mouthful, so we'll just refer to it as LD40 moving forward. But an act to protect liberty and advance justice in the administration of enforcement of the Cannabis Legalization Act and the Maine Medical Use Cannabis Act. That was a sweeping, sprawling bill with a number of parts and sections. And so we're going to kind of break it down across those three big buckets we talked about at the beginning. Changes affecting both programs, changes affecting medical, changes affecting adult use. So right now, we're going to talk about those changes affecting both programs. All right, thank you. Give me just a second to get to my notes. I want to make sure I give you all the information you need. So like I said, LD40 made a number of changes to both the medical and adult use programs. The changes that affect both programs are obviously updating the definition section. You will see alphabetized definitions in the medical and adult use cannabis statutes, which is very exciting for everybody because they haven't been alphabetized since at least before the switch from marijuana to cannabis throughout the acts. You will see an elimination of criminal history record checks for employees and assistants. That went into effect back on May 15th. It also creates a 2-year renewal cycle for registry identification cards held by assistants and officers and directors, not caregivers, and individual identification cards. And so the implementation dates for those changes are staggered because otherwise we'd have just a really weird workflow in the office. So the first registry identification cards 2-year term is going to start for renewals beginning July 1st of this year. And then for individual identification cards, that'll start for renewals beginning July 1st of next year. It also creates a process for appointment of a temporary appointee in certain circumstances when the original owners or principals of a business might be unable to continue managing the business. It allows for transfers of suspended registrations and licenses with OCP authorization, and provides requirements related to OCP providing notice to registrants and licensees when we identify a violation of program requirements. Okay, switching gears. We'll come back to LD40, don't you worry. But we are going to take a minute now and talk about legislative changes affecting the medical cannabis program specifically. So, LD 2255, an act to implement the recommendations of the Right to Know Advisory Committee regarding the public records exception. This is a wholesale update of the confidentiality provisions that have been in the Maine Medical Use of Cannabis Act for a number of years. And so it completely repeals 2425A subsection 12 and replaces it with subsection 14. I'm going to talk about what it does, and then we're going to dig in a little bit to the caregiver confidentiality provisions. So first things first, it makes confidential any information that it identifies a patient and allows for disclosure of that information only pursuant to written consent of the patient or in response to a court order or subpoena. You're going to see written consent of whomever's information it is a couple of times, and I want to just note that that is a pretty substantial change, because before, OCP really was in a position where we couldn't even accept a release of information in a lot of circumstances for information that our registrants or our program participants wanted shared. So I do just want to highlight that there is now provisions in the law that would allow somebody who wants us to share their information to sign a release of information. It also makes confidential any information that identifies a caregiver who's exempt from registration. Those are folks who aren't registering with us. So we wouldn't necessarily have that information, much like we wouldn't have patient information. But if we did have that information, it would allow for disclosure only pursuant to written consent, in the event of a court order or subpoena, or in the event that notice to the public is required to prevent or mitigate a threat to public health or safety. And we'll dig into that language a little bit more on the next slide. Another thing that it does is it makes public the final written decision of the department imposing administrative remedies or enforcement penalties. So this is really about the publication of kind of the final disposition of enforcement actions by the department. We certainly have been able to provide aggregated information in the past, but we will be able to make those enforcement actions public moving forward once everything has been sorted out and there's a final order. Next slide. All right, so I want to spend a minute talking about what LD 2215 did and didn't do with respect to caregiver information, dispensary, and manufacturing facility information. So I thought it was really helpful and important to provide some of the language that's in the new law. So it exempts from disclosure all personal contact information of anybody who is registered with the department. So your cell phone number, your personal email address, those sorts of things are exempt from disclosure. That goes back to the Freedom of Access Act, I believe. And so that term is defined in the act. Just want to make sure everybody knows where to look for what is personal contact information. It also, the one exception to that is if a caregiver resides at the same address where the caregiver cultivates, manufactures, tests, packages, stores, or sells medical cannabis, the department may disclose that address to other state, local, municipal officials who are responsible for regulation related to the Maine Medical Use of Cannabis Act. That information in the hands of those other state, municipal, local governments remains confidential, that personal contact information, including the home address. However, in the event that there is a threat to public health or safety, the Office of Cannabis Policy, the department may notify the public of the identity of a caregiver who's exempt from registration, or a registered caregiver, or a dispensary, or a manufacturing facility, or a testing facility that is associated with that threat to public health or safety. So it's a pretty narrow, exception there, and it is really related to those threats to public health or safety. And the location where any cannabis plants or harvested cannabis associated with the threat were cultivated, manufactured, tested, packaged, or stored or sold would be disclosed again under those narrow circumstances. Thank you so much. All right, now we are heading back to LD 40. So with respect to the medical cannabis program, LD 40 also made a number of changes. So I just want to make sure that I'm giving you all of the information you need in terms of implementation. So please give me a second. All right. So LD 40, with respect to the medical program, remove the requirement for having designated parking spots at dispensaries. It permits the use of patient testimonials regarding the palliative or therapeutic effect of medical cannabis that are reported by particular patients related to particular products. And it does require that such statements be accompanied by a disclaimer related to the fact that those statements have not been evaluated by the FDA. It excludes from the existing prohibition on collectives, members of the same household or family who assist one another with their authorized activities. It also creates a process for caregivers, one caregiver to temporarily assist another caregiver without being considered a collective. We heard a lot before the committee related to caregivers who are ill or who need to go out of state or other things, really being concerned about having somebody help them out while they're unable to tend to their businesses because of the collective's prohibition. So it's said very clearly in statute. Now there's a process for that assistance to happen without running afoul of the collective's prohibition. It updated and provided specific examples of major and minor violations in the statute. Those had been updated last year and were again updated this year. And then it more explicitly established a system of progressive enforcement, which was again something that started during the first special session last year, and that work was continued in LD 40. All right, moving right along to the Adult Use Cannabis Program. We have the one emergency bill that we talked about early on in the presentation, an act to change the requirement for edible cannabis products to be stamped or embossed on each serving with a universal symbol. So as I mentioned, that was an emergency. It's in effect now, has been in effect since April 21st. And it adds cannabis gummies to the list of edible cannabis products that are deemed per se impracticable to stamp, emboss, mark, or mark with a universal symbol. It also allows for that universal symbol to be affixed to individual servings of cannabis products using a wrapper or a blister pack rather than embossing or marking the symbol directly onto the edible cannabis product using molds or edible paint and that sort of thing. So it just provides some additional ways for folks to make it clear to consumers and non-consumers alike that the edible in front of them does contain cannabis. We do want to make it, we have already issued guidance regarding the implementation of that. So if you're an edibles manufacturer, please make sure you've seen that. And we did bring up at the public hearings and work sessions related to this our concerns related to folks who don't mean to consume cannabis, accidentally consuming cannabis if it's not appropriately marked. And so we do just want to remind everybody that OCP has distributed 5,000 safe storage bags across the state to medical and adult use retail locations. Those are free of charge to consumers, so keep an eye out. If you are a consumer and you're buying edible cannabis products, make sure you pick up one of those safe storage bags to keep your edible cannabis products out of the hands of folks who shouldn't be or don't want to be consuming cannabis. That's it. Yeah, okay, great. Again, I'm going to do my best to highlight when things are going to go into effect sooner than August 9th, 2024, as well as those things that are going to require a plan of record update. But for a complete list of those effective dates, please don't hesitate to review the written guidance that we previously issued related to changes this session. So we'll going back to LD 40 again. Again, LD 40 made a number of changes to the Adult Use Cannabis Program. And I'm just going to walk through all of them, so buckle up. So first things first, it allows licensees or explicitly permits licensees to connect to our inventory tracking system metric using an API. This was existing functionality, but it's now spelled out in the law, which is helpful. It also created a definition of principal and makes criminal history record checks mandatory for principals once every 2 years. It also limits tax and license compliance requirement inquiries to principals. Let's see. It limits notice to OCP of transfers of ownerships only to those transfers of ownerships that result in new or existing owners obtaining an ownership interest in the license of 5%, at least 5%, instead of requiring notice, and then requiring notice for all other transfers at the time of renewal. See, sorry, there is a lot to cover. It strikes the requirement that co-located adult use cannabis licensees be separated by a single lockable door. If you are a licensee and you are co-located with another license and you are planning to remove the single lockable door from your licensed premises, please note that you need to file an updated plan of record and have that approved before you can implement that change. It also explicitly permits the co-location of medical and adult use cannabis businesses so long as there's a common but not necessarily identical ownership of the medical and adult use cannabis businesses. And this is really only applicable to cultivation facility licensees and products manufacturing facility licensees. Medical and adult use retail sales are still prohibited from being conducted in the same building or facility where a licensed store that is also has a medical store. So there have been no changes to that provision related to retail sales. Just want to make that super clear. Next slide, thank you. So there's going to be on this next page, a lot of things requiring rulemaking and plan of record updates and standard operating procedures. So we'll go through those one by one. We have a definition in statute now regarding what does it mean to have a visually conspicuous delineation of co-located medical and adult use cannabis cultivation areas. That's now clearly defined in statute. It also provides explicit language in statute related to gifting of seedlings and seeds to a cultivation facility licensee. This is something, at least with respect to seedlings, that has been permitted in the program for a couple of years by rule, but the statute has now been updated to reflect that. Seeds have also been updated, added to those, which were also addressed in the last round of rulemaking. Let's see. It permits a products manufacturing facility to use the portion of their licensed premises that is licensed by the Department of Agriculture, Conservation, Forestry for the production of foods that do not contain cannabis, but not the production of foods that contain hemp. See here, and I do just want to note that that change will require an update to the rules, so that will be included in the rulemaking that we do that will be adopted later this fall. So that will not go into effect. The use of manufacturing facilities for production of non-cannabis foods will not go into effect until those rules are updated. And of course, that will require a plan of record update as well. Let's see. It is going to expand the definition of visitor to include anyone who's not a minor and permits visitors to enter and remain in limited access areas of all cannabis establishments. It will that will also require an updated plan of record, which will require approval by the department. It will permit licensee to request retesting for potency of a portion of the remaining composite sample that was submitted to a cannabis testing facility. the representative sample that was originally submitted by the licensee requesting the retesting. That is going to require most likely cannabis testing facilities to update their standard operating procedures related to sample retention. And again, that will not go into effect until August 9th. I just got an email about that yesterday. So, and then, thank you all for your patience. It permits cannabis store licensees to give consumers samples of cannabis flower, edible cannabis products, or vape cartridges within certain limits. That is going to require rulemaking in order to be implemented. And so we will include that in the major substantive rules that we are going to adopt later this year. Continuing on LD 40. It permits the entry of individuals under 21 years of age, which is now defined as minors, into a cannabis store with a parent or guardian, and allows individual identification card holders to bring their minor children into the licensed premises of any other cannabis establishment in an, in an emergency. It also eliminates the concept of an indoor entry area for cannabis store licensees. It permits the resale or transfer of cannabis or cannabis products that have been returned by one licensee, not a consumer, but one licensee to another licensee, the licensee that provided that cannabis or cannabis products to them in the first place, as long as those returned items are in the sealed, tamper-evident packaging that they were sent to the licensee in the first place. It eliminates the requirement that cannabis and cannabis product packaging be opaque. It creates a process for OCP to review packaging, labeling, advertising, and marketing materials of a licensee to determine whether those items are in compliance with program requirements. Just trying to make sure I don't miss any. It again, it updates and provides specific examples of major violations affecting public safety, major violations, and minor violations. Establishes a system of progressive enforcement for the adult use program, and clarifies the circumstances under which OCP may apply an administrative hold. So before I turn things over to Hudak, I do want to give you just a little bit of a sense of what's going on with the adult use program rulemaking. We've referred to it a number of times throughout this presentation. And I just want to make sure that everybody's clear on the timelines related to that. So LD 40 did a number of things. We've gone over a lot of them, but one of the things that it also did was it authorized OCP to finally adopt the major substantive rules that we promulgated over the last year for the Adult Use Cannabis Program. So like I said, the Maine Administrative Procedure Act requires that major substantive rules be finally adopted within 60 days of the legislation, the effective date of the legislation authorizing their adoption, which is August 9th is the date when that law will go into effect. 60 days after that is the date by which we have to finally adopt those rules. And then those rules go into effect 30 days after we have finally adopted them. In the meantime, if you're trying to figure out which rule is controlling right now, it's Chapter 1. It's the Adult Use Cannabis Program rule that the office has been operating under for the last 4 years. That will continue to remain in effect until we have finally adopted those new rules. We have been directed to update the rules in LD 40. Those major substantive rules need to be updated to reflect the legislative changes that have been made during the past session. So everything that we just talked about, we're going to need to update the rules to reflect those changes. And until we have finally adopted those rules and those rules become effective, we will not be able to implement the following changes. So consumer samples, there's a number of packaging and labeling and testing transfer requirements associated with that we need to spell out in the rules. The use of Product manufacturing facilities to manufacture non-cannabis foods, also going to require that major substantive rulemaking. What we talked about last year, which is contained in those rules and will go into effect at the time that we finally adopt those rules. Cannabis store licensees conducting sales of cannabis and cannabis products at specified events, and delivery sales by Tier 1, Tier 2, and nursery cultivation facilities and product manufacturing facilities will not go into effect until those rules are implemented. So just want to make sure I haven't missed anything. Again, please feel free to, if you've got questions about the timing of different things, don't hesitate to reach out to me. But first, please do review that, I think it was 7-page guidance document that we issued a couple of weeks ago. That does go into greater detail regarding the changes. It's got links to all of the bills, and it has timelines associated with implementation of all those different parts that I have been trying to highlight as we've gone along. So I think that's it with respect to legislative changes and rulemaking, but I am going to look to Lexi to see if there was anything I missed. And then I'll turn it over to Hudak. Thank you all.
Thank you, Gabby. I think we can turn it over to Director Hudak, and then we will get to questions at the end.
All right. Thank you, Lexi. Thank you, Gabby. Good morning, everyone. I wanted to take a little bit of time to talk a bit about federal rescheduling, what it means, what it doesn't mean, and what the process will be like. I know that there has been a lot of speculation, commentary, and unfortunately some misinformation that has been out in the ether here in Maine and in a lot of other states. And so I wanted to take a little bit of time this morning to talk with all of you about OCP's perspective. I'll also talk a bit about the rescheduling rulemaking process in general. This is a topic that I've been researching and writing about for a decade now. And so I'm happy to bring forward some of that research to the conversation that we'll have now, and of course, moving forward. First, I wanted to talk a little bit about the process for rescheduling. So it's important to note that the Biden administration initiated the rulemaking process to reschedule cannabis from a Schedule I substance to a Schedule III substance. It's important to note that cannabis is not yet rescheduled. That rulemaking process, just like the rulemaking processes in Maine, are subject to the Administrative Procedure Act of the United States. It is a long process. It is one that involves public input, just like you do for our rulemaking processes. If you are interested in the rescheduling decision, I strongly encourage you to exercise your rights as citizens and or as residents to submit comments to the federal rulemaking process through the Department of Justice, if you're so inclined. But as I said, it is a long process. It is one that will take months. And then once the final rule is published by the Department of Justice, of course, like a lot of rulemaking, like a lot of regulatory policy, it could be subject to litigation, lawsuits. There could be states that or businesses that don't want it rescheduled. There could be activists or other interest groups that don't like the final outcome. And so lawsuits are possible or probable in this space. But moving on from that, I will say there is maybe an outside chance that the rulemaking process finishes by the end of the year. But I think that is an outside chance. There is a much higher probability that this will be dragged out in the courts for some time after that. From the perspective of OCP, rescheduling has no impact on Maine's medical or adult use cannabis programs. What rulemaking in this area does to reschedule cannabis from Schedule I to Schedule III simply changes the definitions surrounding how the substance is categorized. So for the first time, the US government will acknowledge that cannabis has medical value and can be used to treat certain conditions. And so what that allows for is a different way in which researchers conduct research on the plant. It lowers some of the bureaucratic hurdles to do that research. In some ways, it lowers the costs slightly of doing that research, but it has no impact on state-level legal programs. What I've been telling people is that in the eyes of federal law, the cannabis programs in Maine or Massachusetts or California or New Mexico are just as illegal under Schedule 3 as it is under Schedule 1. And so in a lot of ways, nothing changes for our programs. At the same time, however, there have been a lot of arguments out there about what Schedule 3 status actually means. And I want to run through some of the, now that I've talked about what rescheduling does, I want to talk a little bit about some of the flawed arguments that are out there about what Schedule 3 is and sort of dispute those a bit and push back with some additional evidence. One of the claims that's out there is that by moving cannabis from Schedule 1 to Schedule 3, suddenly DEA and FDA will have authority over cannabis, and that's going to lead to a massive nationwide shutdown of state legal cannabis businesses. The reality is DEA and FDA have authority over Schedule 1 substances just as they have authority over Schedule 3 substances. DEA is granted that power in the Controlled Substances Act. FDA is granted that power also in the Food, Drug, and Cosmetic Act. And so this idea that there's somehow been a change in the agencies that have enforcement power at the federal level over cannabis is just flat out false. And so my argument always is, if the federal government categorized cannabis as a Schedule 1 drug, as what is quote unquote considered the most dangerous substances that we have, why would they then choose to enforce against it when the federal government determined that it wasn't as dangerous as it was? And so the reality is that there's no political appetite for the federal government to begin intervention in state legal programs simply because there was a movement from Schedule 1 to Schedule 3. And it's important to remember that this policy decision does not exist in a vacuum. We're operating in a presidential election year. Cannabis reform, as all of you know, is an extremely popular issue. If you look at polling, both medical and adult use cannabis have higher approval ratings than either of the men who are going to be running for president this year. And so it would be foolish for a candidate or a sitting president to come out and try to use Schedule 3 as a means of shutting down state legal programs. It's also even more difficult because while the federal government has had power for some time to engage in certain types of enforcement in state legal programs, they've chosen not to do so for a variety of reasons. And it's hard to imagine that now that the programs across the states are so large, this is the moment that they would choose to step into the fray and try to shut things down. It's just an enforcement issue for the federal government that there are not enough resources to do if they wanted to, but there's also not really political will to do that at this point. The next claim that I find problematic is that the movement from Schedule 1 to Schedule 3 will mean that Big Pharma is just going to take over the industry. I know that Big Pharma is a boogeyman within this policy conversation and has been for decades, really. But the underpinnings of this idea that suddenly pharma is going to step into this space and take over rests on an assumption that the pharmaceutical companies could not do anything with cannabis as a Schedule 1 substance. That is flat out false. The pharmaceutical companies and other researchers in the United States and around the world have been studying cannabis as a Schedule 1 substance. A pharmaceutical company has brought a cannabis plant-based pharmaceutical to market and gotten FDA approval for it. That's Epidiolex. And so the idea that suddenly this movement is going to initiate the pharmaceutical industry to jump into this space doesn't really hold water. When you look at the reductions in barriers to research that rescheduling from Schedule 1 to Schedule 3 will mean, those costs, while they might be meaningful to an individual researcher, those cost reductions are rounding errors for companies as large as a pharmaceutical company. And so there's no real change in incentive here for pharmaceuticals to get into the cannabis space now, or I should say, when Schedule 3 happens, relative to Schedule 1. And so the expectation from some that this is just going to open the floodgates really doesn't match up with the realities of how pharmaceutical research is conducted in the US. Next, I want to note that there's also a claim out there, or a misunderstanding out there, that moving away from Schedule 1 means that medical and adult use programs in the United States are suddenly legalized. As I said earlier, they're not. The state level programs remain just as illegal under Schedule 3 as they do under Schedule 1. But that said, there are still protections in place. There is congressional legislation that prevents the Department of Justice from enforcing against state legal medical cannabis operations and their regulatory programs. In addition to that, even though the Cole memo was rescinded in 2017, the Trump and Biden administrations have both operated as if the Cole memo were still in place, and we have no expectation that that is going to change at the current time. Next, the misunderstanding is that the movement from Schedule 1 to Schedule 3 opens up interstate commerce. That is also false. If you're a cannabis business owner in Maine, the movement to Schedule 3 does not mean you can start selling your products in Massachusetts or Vermont or Connecticut or Colorado or California. Those requirements for the market to remain closed loop, that is, that the only cannabis that can be legally sold in Maine is cannabis that is grown and manufactured in Maine, will stay in place under Schedule 3 in the same way that it was in place under Schedule 1. And finally, one of the substantive changes that I think could matter for the industry when Schedule 3 status happens is the potential for tax relief for cannabis businesses by extending the types of tax deductions and tax credits that are available in federal tax law. As a lot of you know, Section 280E of the Internal Revenue Code prevents businesses that produce Schedule 1 or Schedule 2 substances from accessing federal tax benefits, most federal tax business benefits. And the expectation is that that will transition away in Schedule 3. But it's important to note, and I will say I'm not offering tax prep advice on this. As I noted, the movement to Schedule 3 has not formally happened yet, and it will not formally happen until the final rule is published. And so it's important for businesses not to expect to be able to write off those standard business credit deductions and take those credits this year, unless you hear otherwise from the IRS. The last thing that we want at OCP is for businesses to start doing tax planning because they think rescheduling has happened already, or they think it will be in place by the end of the year, and that the IRS will honor those deductions and tax credits. And so it's important in that sense, from a tax planning perspective, just to hold tight, to wait to see how the regulatory process plays out, and to wait to hear guidance from the IRS once rescheduling is finalized. And so I'm going to stop there. I'm going to turn this back over to Gabby and to Lexi to see if anything else came in. But I thank all of you, and I hope that you have a healthy and happy summer.
Awesome, thank you, John. I think we have been answering most of the questions over in the Q&A function, but we'll wait another minute or two in case anyone has some questions about federal rescheduling or any of the legislative updates. As a reminder, you can find the guidance document going into more detail about the legislative updates on our website. And one more question is coming in. Is the potency retest allowed in medical or adult use? That's adult use. And we will also be launching a quick poll for feedback about today's webinar. If you could take a moment to answer that, we would really appreciate it. And unless any other questions come in, we will stop here. And again, this recording will be available on our YouTube channel later today. So please be sure to check that out if you ever need to reference some things that we covered today. But one more question about samples, Gabby.
I'm sorry, I don't understand the question. Sorry.
Oh, perhaps that's about consumer samples and the timeline for that.
Okay, when I hear samples, I still think of testing. Adult use consumer samples will be included in the updates to the major substantive rules that we will be adopting later this year. So those adult use consumer samples will not go into effect until those rules are in effect.
All right, I'm not seeing any more questions, so I think we can stop there, but feel free to contact us if anything else comes up.